Appeals Division 1 is now in session.
Good morning. You may be seated. Thank you. We are here on our case number 1CACV150532, in re the matter of the conservatorship for Kathy Hart, Nevens versus AZHH, LLC. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so we'd be grateful to you if, when you approach the microphone, you would give us your name and the name of your client. We have reviewed, we've read the briefs, studied the record, and we've also discussed the case in our conference. So with that, you may proceed.
May it please the court, good morning. My name is John Breslow. I represent the appellant and the plaintiff in the underlying jury trial in this matter, Kathy Hart, or more specifically, the estate of Kathy Hart. We're here today because it's the appellant's position that the trial court made several errors during the trial, most significantly impacting the issue of causation. And I'm going to focus mostly on the causation issues because I think they're the most striking. And for one other reason, we know that the jury was confused on the issue of causation, and we know that because the only question that the jury asked during deliberations was on the issue of causation. And then when we asked the trial court to direct the jury to the specific jury instruction that would have resolved that question, that is, with respect to a pre-existing condition, the court denied our request and referred the jury generally to the jury instructions. But importantly, those several issues of error with respect to causation affected the outcome of the case, and I believe we know that by the jury's question. But I think that the most significant error was not allowing the plaintiffs to call a rebuttal expert. And as the court knows, Arizona law protects the right to call rebuttal testimony. There's a rule of civil procedure on it, Rule 39, and this matter before the court today asks us to reconcile Rule 26 with respect to one expert per issue with the unfettered right to call rebuttal testimony. And I'd like to use a couple hypotheticals, if I could, to illustrate the problem that the plaintiffs have been put in this case. And we described it as a Sophie's choice in our brief, and that is we can either call an expert that will prove our theory of the case, or we were forced, in this case, by the trial court to choose between that expert and an expert that could rebut the defense theory in the case. And that just puts us in an untenable position.
Is it really an either or? I mean, as I understand it, the defense vascular surgeon's opinions were well known. And so if you had wanted to, you could have perhaps either obtained an expert who could opine both about pressure ulcers, which was your contention, and vascular issues. But could you not also have asked the trial judge to allow you to present both experts in your case in chief? I mean, I guess I'm coming from the point where Judge Bassett kept saying, but you knew about these opinions and you chose Dr. Silva. So.
Well, we didn't make a choice. I mean, we listed both in the pretrial statement, neither of whom were objected to. So we had two experts. We could not, I mean, could we have found a vascular surgeon who also understood the causes of pressure ulcers and had treated them in the hospitals? I don't know. But let me use this hypothetical because I think it'll illustrate the problem. I'm going to use two. One, let's assume this were a motor vehicle case. And the plaintiff's theory of the case was that the accident was caused by excessive speed and called an accident reconstructionist. And the defense thought their theory of the case was that the accident was caused by brake failure. And they called a mechanic. What Judge Bassett is saying is that we cannot call a mechanic to rebut the defense position. And what Judge Downey, I think you're alluding to, is, well, couldn't you have found a mechanic who also can do accident reconstruction? And there just simply isn't any law that recognizes that, nor, and in fact, all of the law is to the contrary, that says that if the issue cuts across several specialties, then the law needs to be, the court needs to be liberal in allowing those experts to testify.
How important is it, in your view, that no objection was made in the pretrial statement to your vascular rebuttal witness?
Well, it was huge for a couple of reasons. Number one, it put Judge Bassett in a very difficult position. The problem with Judge Bassett's ruling is that, as a matter of law, he misinterpreted Rule 26. He said, I interpret issue to mean element. So in this case, the element was causation. You already had a causation expert testify, and therefore that's my ruling. That was an error of law.
So you understood him to be saying it doesn't matter whether you disclosed it, whether it was objected to, whether your guy was objected to or not. As a matter of law, he wasn't going to allow him to testify anyway.
That's what he said, correct.
Because it was one issue.
Let me revisit that issue, because I've got the transcript in front of me, and I think this is a real important issue, because this topic, I think it's your best argument, and I think the standard of review matters. Judge Bassett says, I guess I understand the law as speaking in terms of the subject rather than the specialty. If your expert is Silva, then he could testify to rebut what the doctor said on causation. I'm not seeing that Judge Bassett committed an error of law in determining that causation is an issue as defined by Rule 26. What I'm understanding is that possibly, your argument is, he abused his discretion by not allowing or deviating from the presumption set forth in Rule 26, and that would be a discretionary call. So I think the standard of review here is a bit of a hybrid. I don't see from the record that he misunderstood Rule 26. I think causation is an issue, but he had the discretion to allow you to call another causation expert.
Well, except I disagree that that's what he said. Now, if he, well, I have it right,
Okay.
yeah, I have it right here, the same subject, in my opinion, causation. So he's saying that the issue that we're talking about is causation.
So you're saying he didn't, from what he said, he's not acknowledging, I have the discretion to allow you to go ahead and present your second expert.
Right. He's saying you called your causation expert and you happen to have chosen an internal medicine doctor, and you only get one expert on the issue of causation. That's what I interpret him to say. And if that was his ruling, that is an error of law. Now, if he was ruling that...
Well, generally, causation is one issue.
Well, I disagree. And that's where I get to my hypotheticals.
Well, but what case law authority stands for the proposition that causation isn't an issue? I think causation, the elements of negligence would all be issues.
Well, but we know from the Felipe case that's not the case. Because in Felipe, they were allowed two experts on the issue of damages.
Well, but that again was reviewed for an abuse of discretion. The problem with all the cases out there is the appellate courts tend to affirm based on whatever the trial judge ruled in exercise of his or her discretion. So I'm not finding any of those cases very helpful, because yes, we affirmed a decision.
Well, let's take your presumption that this is an abuse of discretion standard. As we know from the Felipe case, and basically all of the cases on this, that the only reason for the one expert per issue rule is to prevent cumulative testimony. And that dates back to the days in medical malpractice where I'll get two general surgeons to testify and the defense will get three and then I'll have to get four. That premise is articulated very clearly in Felipe. It's the only reason for this is to prevent cumulative testimony. Well, in this case, Judge Bassett didn't do anything to determine whether or not this testimony was cumulative. I mean, all he said was, you've already had an expert testify on causation, and you get one expert on the issue of causation. We know from the record now that this testimony is diametrically opposed. The hypothetical I wanted to give was this. If there were a medical malpractice case in which a surgeon nicked an artery and the patient bled out, and I hired a general surgeon to testify that the artery was nicked and the patient bled out and that was the cause of his death, and the defense hired a hematologist to say, no, what really happened is he had a blood disorder, and that's what caused his death. We're still talking about the issue of causation if we're going to go there. But clearly, clearly the plaintiff has a rebuttal case under Rule 39 and can meet that evidence and call a hematologist. The plaintiff cannot be born with the burden to find a general surgeon who also has an expertise in hematology in the hopes that that's the defense that gets chosen so that he can rebut that defense. That's the conundrum that the plaintiffs are being placed in. And it's even more problematic with the Beckendorf decision, which says that the defense can raise all sorts of possibilities. So, for example, in this case, they could have hired a pulmonologist to say that her smoking was the cause of the pressure ulcers, or an endocrinologist to say that her diabetes was the cause. And what Judge Donnie, I hear you saying, is that I have to anticipate all of those defenses and hire.
I think that's their argument. I didn't mean to say that was my position.
But I have to anticipate that and hire one expert on the issue of causation that can possibly address everything that they could possibly raise. And I think that's why, to get to your point, was it appropriate for me to wait to call my vascular surgeon? I mean, that's what he was there to do, was to rebut their theory of the case. And they may not have chosen. I mean, I knew they would do that because we'd all disclosed these experts. But during the discovery phase, I don't know what theory of the case they're going to choose to defend the case upon. So,
at trial, during trial, when this issue was argued, did Judge Bassett know that your second expert had been disclosed and was not objected to in the pretrial statement? Did you raise that issue with him then?
He knew that expert had been disclosed, and there was no issue with respect to the disclosure of my expert. I did not. The argument that occurred happened in about 5 minutes, and I didn't raise the fact that they didn't object in the pretrial. That was raised in the motion for new trial. And the judge didn't comment on it in his ruling, so I don't know what his thoughts were with respect to that. But it clearly prejudiced Judge Bassett, because if we are talking about an abuse of discretion standard, what would that would have done if that objection had been in the joint pretrial is that then we could have had an offer of proof like we had at the joint at the motion for new trial, where we had the testimony in the record, we had the deposition testimony of Dr. Collier and the trial testimony of Dr. Treeman and Dr. Caparelli, and then our standard of care expert. And when you read those now, or as we did at the motion for new trial, there's just absolutely almost no similarities between what Dr. Silva testified to and what Dr. Collier would have testified to, and because they couldn't, I mean, they didn't have the same expertise.
And does that establish the requisite prejudice if we say that the court abused its discretion? What demonstrates the prejudice your client suffered?
Yeah, the fact that we could not rebut the opinions of the defense expert and their theory, and the only way to do that was to call someone similarly situated, which was a vascular surgeon. And we know from the 18 cases that we cited that we have the right to rebuttal case. We don't have the right to choose their defense, but clearly we have a right to put on an expert to meet that proof. And that, under the definition of cumulative that's defined in Felipe and Felder, this clearly would not have been cumulative testimony. I mean, it just, by definition, it could have been. In fact, we know from the defense's position in closing argument that it's not cumulative, because they stood up and took full advantage of the fact that they had won this ruling and said, oh, the plaintiffs, Dr. Silva's a nice guy, but they just called the wrong guy. What they really needed was a vascular surgeon, like our vascular surgeon over here, and I'm sitting there with my vascular surgeon sitting out in the hallway, having been prevented to testify. So, I mean, clearly they took advantage of this error that the court made and compounded it. And then we have on top of that the other causation issues. But I think if we read the case law on rebuttal and the right to rebuttal, along with the four cases of this court on the issue of experts, and I mean, none of those cases precluded the additional expert. And for example, in Felipe, not only did they permit two experts on the issue, if we're going to define it that way, of damages, but they were two statisticians that were very similar, and the court expressed its frustration with that. And that's why I think it tried to come up with this blanket rule. The court went into Felipe and said, well, I can't tell the difference between these two experts, and then went on to say, so I see this as all one issue, and the issue being causation. And clearly, if that is upheld, whether it's abuse of discretion or de novo, it prohibits a plaintiff from ever being able to meet the proof that the defense puts on. They can always choose a defense, especially under Beckendorf, which says it doesn't have to rise to the level of more likely than not. They will always be able to put on evidence that we as a plaintiff cannot meet. And
I think I hear you suggesting that if the issue had been raised before trial so that the trial court was aware of it and had full time to consider it, the ruling might have been different.
I think so, Your Honor.
I suppose either side could have raised it before trial.
Well, I mean, we listed our expert, Dr. Collier, and Dr. Collier was deposed. I mean, there was no way to see this coming. I had no idea that they would be objecting. They called two vascular surgeons. They called the treating vascular surgeon, and they called Dr. Treeman, their expert. And I'm sitting there waiting to rebut that testimony as any competent trial lawyer would do, and I had him ready, willing, and able to testify. They knew I was going to call him. And then he was pulled out from under me at the last minute. And there just isn't a case in Arizona that supports that ruling. I mean, even under abuse of discretion, the cases have always permitted the additional expert to testify. We don't.
You would agree that if Dr. Collier had been an internist, an infectious disease specialist, who was simply going to rebut, I guess that wouldn't be rebuttal, though, because it wasn't the defense position.
Right.
If, very hypothetically speaking, we were to agree that there was error on that ruling, it seems to me the only additional matter we would need to discuss that you've raised is the loss of consortium issue. Is that correct?
That is,
the others,
yeah, they all essentially argue for a new trial. That's the only one that stands on its own.
Yeah, because the other ones might not recur if there were a new trial. I mean, the non-party at fault, the testimony by the former employee, I mean, those would.
Wouldn't the non-party?
Well,
would reoccur, wouldn't it?
Well, the best argument.
The timing of that was the problem here.
Exactly.
And so the timing of the court allowing the non-party at fault, I think, was.
I mean, they don't have an expert on that issue. They tried to use our expert. The rules changed in midstream. But with respect to the loss of consortium, I think the Miller case now this resolves that issue in our favor. That there's a two-part test. We introduced evidence of both parts of that test. That's there must be a severe, permanent, and disabling condition, and there must be substantial interference with the normal relationship. And we established both of those things during the trial. I mean, this is a woman who was.
Was there evidence that this was a permanent condition?
Absolutely, okay. Absolutely. In fact, we had a life care plan that calculated damages out until the end of her lifetime. Right. So, with that, I'll reserve my time.
May it please the court, my name is Joelle Sharman. I'm with the law firm of Lewis Brisbois. We represent the appellee AZHH, which I'll refer to as the hospital. This appeal involves several evidentiary and procedural rulings made by the trial court within its discretion over a 9-day jury trial. The court should affirm the denial of Ms. Hart's motion for new trial because nothing in the record supports that an abuse of discretion occurred.
Let me jump right to Dr. Collier, if I could, because I do think that's their strongest argument. Judge Bassett ultimately says, I'm going to grant the motion to preclude Collier as a duplicative expert on the issue of, first as standard of care, causation. How was Collier a duplicative expert? Yes, he was going to talk about causation, but a very different kind of opinion on causation than they had previously offered from Dr. Silva.
Well, Judge Downey, you said it correctly when you asked opposing counsel during his argument that the standard of review here directs that answer. And defining the scope of an issue for purposes of causation or for whatever, for purposes of duplicity, I don't want to say duplicity,
Duplicative.
is within the court's discretion. Felder
It
says
is,
that.
but the court has to have before it information within which to exercise its discretion, and I'm struggling to see what Judge Bassett had in front of him that allowed him to say Collier was duplicative to Silva.
Well, it's not even so much what Judge Bassett had before him. It was the failure of counsel for Ms. Hart to make the proffer that Dr. Collier was going to impeach the testimony of the hospital's expert witness. Counsel has conflated rebuttal and impeachment evidence. The plaintiffs here had the burden of proof. During their case in chief, they could have called Dr. Silva and Dr. Collier. They chose only to call Dr. Silva. Importantly, on page 4 of the reply brief, they concede that their decision not to introduce Dr. Collier's testimony during their case in chief was pure strategy.
Do you think, are you saying that your client would not have objected? Had
They may
the
have.
plaintiffs chosen to offer the second expert in their case in chief?
They may have.
So I don't get this argument then. How is it?
The trial court had the discretion, regardless of whether there was an objection posed in response to the pretrial stipulation, to allow or disallow that evidence in. The proffer was not made during the case in chief to allow that expert witness in. And that was the strategy that the plaintiffs chose.
So then it comes up on rebuttal.
Rebuttal would be impeachment. It wouldn't be rebuttal. The defendants did not have any burden of proof. We had to rebut their expert, Dr. Silva, on the issue of causation, which we did. Had counsel offered Dr. Collier's testimony for the purposes of impeaching the truthfulness, the character, or the credibility of any of our experts, we'd be in a different scenario. But that's not what counsel proffered. Counsel proffered to introduce a new expert for the first time after he had already rested on an issue that he could have raised.
Which wouldn't have been relevant until the jury heard from the defense.
The record does not support that.
Explain.
The record supports that on both issues, both Dr. Collier and Dr. Silva were going to testify as to the issue of causation. They were allowed 3 experts to testify on the issue of standard of care.
No, but we're not dealing with that. We're talking about causation here.
The trial court determined in its discretion that causation was one issue, and that Dr. Silva and Dr. Collier both were, and that's what the proffer was for. The proffer was for rebutting the issue of causation from a vascular perspective. In the initial case in chief, the plaintiffs could have offered either or both. They chose not to.
They would have been offering Dr. Collier, if I have the name right, the vascular surgeon, they would have been offering him perhaps with some prefatory statement that we anticipate the defense will argue this position. Here's our expert to address that.
It's speculative, though, Your Honor, because the record doesn't reflect that, because it didn't happen.
But what about the failure of the defense to object to Dr. Collier in the pretrial statement? He's very clearly listed, and as we know from the rule, objections not made in the pretrial statement are typically waived.
Procedural Rule 16G7 allows the court to modify those rules, and in any event, the time
Wait. So the defense did have a duty under the rules to object to the witness at the pretrial phase.
Felder says that it could object either then or at the time of proffer.
But what about the rule?
The rule is a best practice. Should they have? Maybe, but it wasn't ripe to object at that point, because at that point, counsel didn't know whether plaintiffs were going to offer Dr. Silva or Dr. Collier or both. If they had offered
They were both listed, so it
Yes.
seems to me consistent with Rule 16G2D, which says you have to list your witness. Each party must list any objection to a witness and the basis for that objection. Unless the court orders otherwise for good cause, no witness may testify other than those listed. And they've clearly listed Collier and Silva. That gives me some pause.
And their depositions were taken, so you knew what they were going to say.
Absolutely. And at the end of the day, counsel concedes that it was a strategy decision not to call Dr. Collier, and it was a discretionary call by the trial court not to let him do so in rebuttal.
I don't think he's conceded that, the second. What case have you got to cite us in which the Court of Appeals affirmed a decision by the trial court under this rule to preclude another witness on rebuttal?
Factually, I don't believe there is a case on all fours, but Felder says that you can object at the time of proffer. Felipe, which counsel cites, is factually an opposite and actually supports the trial courts having allowed plaintiffs to introduce 3 separate experts on the issue of the standard of care. The trial court, in its discretion, allowed them to do so. The trial court, in its discretion, denied them the opportunity to do so on causation.
But I'm being a little redundant, but I'm not sure I understood what in the record gives us confidence that Judge Bassett truly exercised his discretion. I mean, Mr. Breslow did not exaggerate in saying that this discussion happened over 2.5 transcript pages, so it came up very quickly. He decided it very quickly. There's no indication he looked at what Collier would say that really was to be able to compare it to Silva, and he makes the decision he's duplicative, but I don't know what he has to rely on to make that decision.
Based on the proffer that they wanted to call Dr. Collier to rebut the issue of causation from a vascular perspective, without more, that's a 1 expert per issue rule.
Well, so what you're, okay, so if you believe there's a plaintiff is allowed just 1 expert to prove causation, what's your response to the auto accident hypothetical where it's either undue speed or a failing brake?
The facts were completely different. Undue speed, failing brake are 2 completely set of facts.
That's the point.
But there was no proffer in the record here. And there was a proffer in the record in Felipe. And there was a proffer
What's your answer to the hypothetical? Does the plaintiff have to find an expert a single expert who can talk about both brakes
No.
and speed?
No, but the plaintiff's attorney has to make a proffer for purposes of preserving for the record on appeal any evidence that would support an abuse of discretion occurred.
So what plaintiff's counsel should have done at the moment that this issue was raised was to say, but Judge Silva, if I've got the name straight, wasn't a vascular surgeon, didn't talk about vascular stuff. As a matter of fact, disclaimed that I have a vascular guy who can rebut the vascular surgeon. Is that the sort of discussion that should have happened?
Yes, actually. And on page 4 of the reply brief, counsel concedes that he assumed no objection would be made.
Well, that would be a fair assumption,
Not
wouldn't
under
it?
Felder. Felder says you can make an objection at the time of proffer. And the reason why, and it's not, Felder does not support, nor does it hold, that you have to make it both at the time of the pretrial stipulation and at the time of proffer. You can do it at either time. Best practice, should they have done it during the pretrial stipulation? Maybe, but at that time, it was unclear at that time whether plaintiffs were going to call Dr. Silva or Dr. Collier. Whether, if Dr. Collier had been called, Dr. Silva may have been duplicative. There's nothing that stopped the plaintiffs from calling Dr. Silva to rebut the testimony of our expert, Dr. Tryman.
Except that he wasn't qualified to do it. He wasn't
That
a
was his
vascular
choice.
surgeon. Well, I know you're stuck with what Judge Bassett said in his ruling, which is I find that Collier would be duplicative. But isn't that finding undercut fairly dramatically by the closing argument of defense counsel, who makes hay out of the fact that Dr. Silva is not a vascular surgeon, he doesn't have the right experience, he's not qualified. You only heard from 1 vascular surgeon who could tell you the causation about the wound. It seems a little inconsistent to argue on the one hand he's duplicative, but then tell the jury they didn't have a vascular surgeon.
And once again, counsel did not object during closing arguments on that ground, that was an improper argument, did not move for mistrial, did not make any proffer on the record to preserve that for appeal.
Well, but it goes back to whether the court abused its discretion in saying this was a duplicative expert. If he were seeking a new trial only because of closing argument, you'd be absolutely correct. But it informs our decision about whether Dr. Collier really was a duplicative expert to Dr. Silva. And it seems like the defense wanted to have it both ways at different times during the trial.
I think Felder is on point for all of this discussion. The court defines the scope of the one expert per issue rule. The court did not have, at the time of this 2-minute argument, anything from opposing counsel other than he wanted to rebut the issue of causation from a vascular perspective. Nothing stopped him from doing so during his case in chief.
Well, what more, if, to say he wanted to offer a witness to rebut the vascular surgeon, what more in the way of a proffer should have been made at that point to have Judge Bassett understand that this witness should have been allowed?
At the time, as in Felipe, where the two different experts were testifying on two distinct facts that applied to causation, but they were distinct facts. There was no proffer on the record that Dr. Collier factually was going to say that causation did not occur the way Dr. Tryman explained because of X, Y, or Z. There was no proffer at all. It was just
what other, I mean, to me, I would have assumed that was the point of the testimony, given that Dr. Collier had said, I don't know anything about vascular stuff.
Well, that goes back to the whole standard of review of discretion. When the court has to assume something because it's not put in front of the court, it becomes a discretionary call at that point. And the court, in its discretion, decided there wasn't enough here before it to say it wasn't duplicative. And there's nothing on the record to show that that was an abuse of discretion.
It sounds to me like you are perhaps implying or suggesting that the problem here is that plaintiff's counsel didn't make the right argument to the trial judge.
That's part of it, yes, Your Honor.
And if he had done so, then the judge would have allowed this witness to testify.
Or not, and we'd be in a different procedural posture here, and maybe the arguments would be different. But it's all speculative because nothing was made on the record to preserve what they're arguing now for appeal.
But stating to the trial judge words to the effect that I have a witness to rebut what the defense's vascular surgeon has now said, that's not enough?
That's not enough because that's not what it said in the transcripts. The transcripts say, I want to rebut on causation. He already had a chance. It was his client's burden of proof during their case in chief to offer what evidence they had on the issue of causation, not on rebuttal to reoffer something that they had a chance to do so the first time around.
It's not a reoffering if these are distinct medical specialties.
That, under the case law, does not make it a separate issue. What makes something a separate issue, as in Felipe, is something factual other than the overall umbrella issue, something other than causation. Had there been some specific proffer, some argument why Dr. Collier was needed and Dr. Silva was just not sufficient to do the job, we may have been in a different position than we are right now.
I tend to agree, as I voiced preliminarily in this argument, I tend to agree that causation is one issue, but when you have differing, so apparently differing medical specialties, one says causation yes and the other says causation no, why isn't the plaintiff entitled to rebut the causation no?
That's not what Felder holds. Felder holds it's one expert per issue. It's the fact that it cuts across several disciplines gives the trial court discretion to allow more than one expert on an issue, but there's nothing in the record to show that the trial court abused its discretion here because there was nothing before the trial court at the time of the proffer to reflect otherwise.
But on that point, which you've made repeatedly, and I understand, but you didn't object in the pretrial statement. So I read this, and I read them as being caught flat-footed and surprised that this is an objection on the eve of rebuttal. So I think it's probably not a fair characterization of this record to fault them for not making a better proffer at that point because they were proceeding on the merry path that you made no objection to Dr. Collier.
And likewise, opposing counsels at trial made no objection to our objection at the time of trial. At no point when the hospital objected to the introduction of Dr. Collier did plaintiff's counsel say, hey, we're being sandbagged. they didn't object at the time, at the pretrial stipulation. We should have a chance to offer that testimony now for this purpose. None of that was raised. Are there any other questions, Your Honor, on that issue?
Now, talk to us a little bit about consortium, those cases.
Consortium, it's a derivative claim which will rise and fall on the underlying claim. The court's threshold inquiry is whether, assuming that the case is remanded and there's a new trial, the court's threshold inquiry would be whether Ms. Nevens lost the ability to exchange love, affection, comfort, care, and moral support. That is a threshold inquiry for the court, not for the jury.
And what evidence is lacking in this record?
Well, the evidence from Mrs. Nevens showed that they still socialized monthly and they still kept to their routine. She had to take care of her mother a little bit more, and they only went out once or twice a month and not 3 or 4 times a week.
That's not sufficient?
From a threshold inquiry, yes. At the end of the day, if the case is remanded and the issue comes up again, if the court makes the same decision, if new evidence is offered, the severity of the interference is a question for the jury. But the threshold question, has there been that significant interference, is one for the court.
And so the defense's argument is that the court correctly ruled on this point that the fact that they used to get together a few times a week, now they get together just once a month, that's insufficient to prove loss of consortium.
There's an unpublished opinion from 2013, factually analogous.
No, I don't think we're allowed to think about 2013 cases. I think the rule was changed in 2015. So,
and it's not cited in our brief for that reason.
Yeah.
But just there
Were
have been
any of us
instances.
on it?
The answer to that, I don't
I think
know.
we'd find it more persuasive, right?
I don't know.
I want to know what they said.
There have been cases where that threshold inquiry has been answered for the defendants in factually similar situations where there hadn't been that significant interference shown. It's a close call.
Okay, thanks. Thanks for that.
Just to clean up a few points, with respect to the consortium issue, the claim was not with respect to how many times they went out to lunch together. It was the claim that Lori Nevens, who had a mother-daughter relationship with her mom previous to this episode, now had become her mother's caretaker, and the relationship had completely changed. Her mother was now a burden on her, and which caused a tremendous amount of distress on her mother to now be a burden on her daughter when her mother felt like she had the obligation and responsibility to take care of her daughter. And so that it really goes more to counting up the number of times they went to lunch together. With respect to the citation to Felder, Felder does not provide any exception or waiver to the requirements under Rule 16. It just doesn't address that issue. So I don't know if they were referring to another case or misciting, but that holding is not in the Felder decision. The last argument that I want to try to tackle, because with all due respect, I'm having difficulty grasping it, they seem to be arguing that I would have been in a better position had I offered Dr. Collier in my case in chief. And I just cannot see the logic in that as much as I try. I articulated to the court when this issue came up that it was a rebut of the opinions of the defense doctors, the two vascular surgeons that they called. And the definition of rebuttal says rebuttal evidence is that which explains, repels, contradicts, or disapproves evidence introduced by a defendant during his case in chief. So that's exactly what I was trying to do. The only inquiry that should have taken place is, was that cumulative evidence? And I think what the court is alluding to is there's no record to see what the judge, if he determined that it was cumulative as opposed to making a misapplication of law, as I contend, there's just simply no record upon which he could have determined that this was cumulative evidence. And as was cited by Judge Gimel in the Felipe case, the definition of cumulative evidence is additional evidence of the same character as existing evidence that supports a fact established by the existing evidence. There is no way, as we know from their closing argument, that Dr. Collier's testimony would have been as the same character as Dr. Silva's, because one is a vascular surgeon and could rebut the mortality rates, the ischemia, the fasciotomies, the whole mumbo-jumbo of whether or not this was the actual cause of her pressure sores would have been tackled and simply addressed and rebutted, as a rebuttal case is supposed to do, those opinions, and we're simply precluded from doing that. And so I think whether the court takes this on, I admit it's a close call, whether the court takes this on under abuse of discretion, there's no record to support the judge's decision, and if it takes it on under de novo, that it misapplied Rule 26, both of those would warrant a new trial. Thank you.
Thank you. Thank you to both sets of lawyers for your argument and for your briefs. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.